I'm preparing the sign-in sheets to pass around. Welcome, everybody.
We're good.
And then pass them back down so that you can sign them. Yeah. Everything. Oh, not this sign. Okay. Yeah. I'll make it first.
The one about that side. That's the one.
Oh, are we on the record?
Yeah, I
Yes.
think we're on the record and we're just doing the sign-in sheet.
Okay, hello to everybody. While we're passing around the sign-in sheet, let me tell you what I did, Roxy. I sent you by email, I don't have paper copies.
Okay.
I'm still trying to save trees.
Okay.
I sent you 3 more proposals on Article 24, grievance procedure, Article 25, which is disciplinary actions and investigations, I think, and Article 34, which is just the number I've given for right now to an article on promotional bypasses. So, which I separated out from discipline because a promotional bypass is not necessarily a disciplinary action. In fact, I would argue that it's not a disciplinary action. And I think my entire team is here today except for Frank, and we have a substitute for Frank who is
Trevor Jacoby. J-A-C-O-B-I.
Oh, I. Okay.
Put a Y if you want.
Phillips.
Go appropriate.
All right, I received that email with 3 additional proposals and a status sheet.
Yeah, the status sheet just lists the various articles, when we provided proposals. It will show when you provide counters. It will show when, our initial proposals for that matter.
Okay.
It will show when we have TAs. We right now have TAs on 2, I think Article 3 and 5, which were non-discrimination and maybe recognition. I don't remember. Hang on a second, I'll tell you.
We decided to table the recognition until the
okay.
end, because we wanted
So-
to look to see what the whole contract looked like and who it affects, et cetera.
Before you decide to ratify. Okay. Oh, that's fine. I don't, no big. I just amended that. So we have ATA on non-discrimination. And I know y'all are going to want to go back and caucus probably and look at these 3. There are some pretty meaty proposals. I have tried to indicate what parts of your prior proposals and what parts of the contract I've been utilizing in writing these things.
Okay.
While you're doing that, my team and I have another proposal we hope to make today on the impasse procedure that will respond to the proposal that you guys made last year about an impasse procedure. And so we'll be working on that, Rick, while you go over our proposals. Obviously, we welcome any counters for your proposals that y'all have that you want to make today, and let's get this process moving.
Okay. One of the things I wanted to address on the proposals, so far you've given us 3 new proposals today, and they're pretty heavy proposals that we're going to have to go through. I wanted to see if, I think you have, pursuant to your status sheet, in addition to the impasse procedure you're talking about, but 1, 2, 3, 4, 5 more proposals that you all will most likely be coming forward with. Is that correct?
Let me see, promotional procedures.
23 promotional procedures.
Impasse procedure,
28, which is what you're working on.
30, which is miscellaneous. 33,
31,
which is EMS. I'm sorry, I don't mean to be talking over you.
Yeah.
So I really only see those
Oh, I apologize. 31 and 32 were already given to us, is that correct?
Right, we gave
Okay.
those to you at the last session.
Those were
So-
by email at the end, that's why, okay. So we have 1, 2, 3, 4 proposals outstanding.
Right, and I hope to give you the one on impasse procedure today.
Okay.
Which will really then only leave 3, the miscellaneous. And the reason miscellaneous there is just, you know, if there are things in the contract that don't really have a home in one of the identified articles, I'm keeping those for those. Keeping those for those, that makes a lot of sense.
Keeping those for that
Yeah.
section, yeah.
Yeah,
I understand.
and let me just say that the EMS and the promotional procedures are kind of interrelated and sort of a tough nut to crack. And I had made a proposal there that I think y'all are still considering, which is let me see, which team do I want to sign up for today?
The page.
Yeah, well, it's paid,
In theory.
yeah.
Oh, yeah, you know,
Oh,
we're
you
okay
guys keep
with
throwing
that.
that out there. You need to sign both of them.
Oh,
Was that red attorney?
boy, I tell you, you say one wrong thing.
Yes, we know.
Okay,
They get one?
you know, I suggested that for potential IBB. If y'all don't want to do that for any reason, then I'm totally fine with coming up with proposals on those things. Definitely, we intend, I think both sides have made prior proposals about EMS and the promotional procedure, so. And the reason I think they're interrelated is because y'all have this kind of unique feature in your fire department of like splitting the branch, you know, the promotional branch. You go firefighter 2 driver and firefighter 2 EMS. And while I know most people go the EMS route, it's, you know, I mean, it's really one rank, that firefighter 2 rank, but it branches, you know, then comes back together at captain. So, you know, depending on what we do with the EMS, you know, that might or might not be necessary to keep that branching. But, I mean, I think that there are certainly strong reasons why you would want to, and maybe some reasons why you wouldn't. And that, I guess, is what, you know, I would ask the IBB committee, subcommittee to.
Before we would, because that, one of the things I think that would help us figure out and evaluate whether we want to pursue the interest-based bargaining route on those issues is maybe we can have an initial proposal to find out where your interests lie.
Okay.
Do you know what I mean? That would
Yeah.
form a basis, and that way we know, is this something that's really going to work? Are we really on the same page, you know, or is this something that we're just going to kind of go and spin our wheels on for a while and then come back and then we're going to have to start all over again? I think
hear
that
you.
we can both start with a base of where our interests lie. I think that would help my side evaluate it a little bit better, because if we're way off, then interest-based bargaining may not work. If we're close, then it may work, you know, and that would just help us evaluate that a little bit better. So I would
Okay.
ask that you provide initial proposals on both the promotional procedures and the EMS. And what we're doing is we're also preparing our proposals, but as you know, we're here bargaining, this is a unique bargaining session in that we're bargaining a contract from the ground up. And so what we're interested in looking at is what the contract that you're putting on the table, what it's gonna look like as a whole. Because a lot of these provisions, even though they may stand alone when you present them, there's implications on a lot of the other proposals, a lot of the other provisions that come out from the contract. And so, you know, we may tentatively agree to one, or we say, okay, this is working out, but then we come up with, you know, a big, you know, like a promotional procedures or wages, and then something we agree to over here directly affects that. We're not able to, if we do it piecemeal, we're not able to fully evaluate the effect of that. So what we're asking for, and what we plan to do for you, is we're asking if possible, to get the rest of the proposals that you have ready for us. That way when we present ours, we're gonna present to you what we believe the contract should look like. And that's where we're headed, and that's why it's been difficult, because, difficult to say, here's one proposal and here's the other, because one proposal, we may have one proposal and then you submit another one, and then it affects kind of what we need to rearrange, how this is gonna work.
Okay.
And so, that's what we're asking for. And I think we had generally talked about it beforehand. So that's where we're at, and that's where we're trying to evaluate, what does this contract really look like at the end? We want to make sure that once we put all the pieces together, that they work, and they work correctly, because this is the kind of fixed things that need to be fixed.
Right.
Okay?
And I'll say categorically that if y'all just accept all the proposals we've made, it's a contract that will work for us. Okay, what I'm gonna try and do, I hope to have an impasse article for you today. I will commit to trying, how's that for a commitment?
Sure.
I will commit to trying to have a promotional and an EMS and a miscellaneous for you by next week's bargaining session.
Okay.
And that'll give you an entire contract. And then what I would ask you to do, if you're willing, I mean, certainly if there are things that you want to talk about that are not contemplated by our proposals, by all means, just make them new articles, starting with 35. But then, if you could like make yours in the form of like counters showing what you changed in our proposals, that would help us. Because if we just have, competing proposals shooting across each other in the sky, it's going to be a lot harder to compare them. So.
Okay.
And I'm not trying to control the flow. I mean, I'm just trying
I understand. I'll probably be talking to you logistically about how we can handle that before the end, because as you know, fortunately we have until March 5th, because of the short timeline we had with which to prepare for this particular negotiations. We agreed to March 5th, 2015 being the deadline for all initial proposals to be done. And I still see that happening. We're good with that deadline, and we're working with it. And I think we've made a lot of progress, because you all have put, I think, 27 proposals, not counting the ones that you put down today, for us to go through and evaluate and see what we can counter, see what we need to negotiate on, etc. So that's the time. I just want to give you generally where we're going and why it's going this way.
Our next meeting is next Friday, right?
Yes, I was actually going to go over that. We have publicly posted the next 3 meetings, and I forwarded them to you as well as Carlos and Johnny. I want to make sure that you got those. And they've already been publicly posted. The next meeting is Friday, February 20th, 2015. The meeting after that is Thursday, February 26th, 2015. And the next meeting is Thursday, March 5th, 2015. And that March 5th is the deadline to submit all initial proposals for both parties. All the meetings will occur at the same locations that we've been holding these meetings.
And in the same rooms? I mean, are they
same rooms? Yeah.
Very good.
We've been able to reserve, as far as I know, and as far as I've been told, we've been able to reserve the same main room and the same caucus rooms for consistency. Also, I wanted to follow up on whether you were able to gather any of the data that we had requested the last time around. Specifically, we were looking for the data and the information that you were using with regard to Article 10 wages and Article 11 supplemental pays, what you use as a basis for those increases in the proposed increases in the wages and ad pays.
Okay. We'll look at that on the next caucus.
Okay.
You know, and what I'd said to you about that, Roxy, and it's still true, is I need some feedback from you about whether, if we provide that data, because we do have some data, if whether that will motivate the city. In other words, is that gonna, you know, affect the city's counter proposals? In other words, is that gonna be a driver on the final deal we make? Because, you know, we're willing to provide comparable data, and we certainly think it shows what we have said it shows. But at the same time, if that's not gonna motivate the city, why go through that exercise? So I need to know that the city is gonna meaningfully look at that data, and when you make counters to us, you're gonna provide similar data to us about why your responses are as they are.
We would not have asked, other than if we wouldn't have asked if we wouldn't wanted to look at what the basis is and meaningfully look at it. I mean, one of the issues is that you're asking for significant increases in not only the base pays, but a bunch of other ad pays, such as certification pays, assignment pays, things like that. And we need to know the basis for that. You've made statements that we're behind the ball on some of them, but we don't know where that's coming from. We look at our cities, we want to see what cities you're looking at. We want to know what data you're relying on, so that we can compare that. And if it's if it's verifiable data, then that's something that we need to know where you're coming from in order to be able to evaluate what our side is as well.
We try to avoid verifiable data. No, yeah, we'll look at that and we'll try and provide that to you. And, you know, when we get your economic proposals, we'll look at that and we'll be interested in the data that you're relying on.
Absolutely. And I cannot commit to say that once I get the data, it's going to make the city's decision, but we will look at it and we will look at it meaningfully and evaluate it. And we're not asking it for it just for an exercise. We're very interested in seeing, you've proposed this, you've stated that there's an increase needed, and we need to know what the basis is. That way we can at least be informed of where y'all are coming from.
Okay.
Because when I'm talking to my team and my people, and they're asking for this percentage, what is this based on? And I can't explain that at this point. If I can provide them with an explanation, if I can provide them with what your explanation is, it will be more meaningful to them, and they would be able to fully understand where you're understand where you're coming from and be able to evaluate it.
Okay.
Okay.
Okie doke.
Okay, at this time, I guess we're going to ask Secaucus to go ahead and go through your proposals, and we'll come back with questions, and maybe we can get to your impasse procedure at the end of the day, and then go from there.
Okay.
Okay?
Sounds good.
Okie dokie. Everybody get the sign-in sheet? Ready? Okay. All right, thank you. Good afternoon. We received, in addition to the 3 that you gave us this morning, proposals. In addition to Union Proposal Article 24, Article 25, and Article 34 from this morning, you have forwarded to us an Article 28 on impasse procedures. Is that correct?
That is correct.
Okay. We went, I just want it for the record to show that you've sent that to us. We've
Okay.
also reviewed it, and so we're prepared to ask questions on that as well this afternoon.
Okay, very good.
So let's start with Article 24. And this is the grievance procedure. I have quite a bit of questions through here, but I think we can get to them. I'm hoping we can get to them pretty quickly.
Hope dies last.
Yeah. And it is Friday afternoon, Friday the 13th. One of the words, I keep seeing this this term called orderly adjustment, which was also included in your preamble and intent proposal. And I know we discussed it earlier, but it really is, I want to prevent any ambiguousness, and I want to know exactly what is meant by orderly adjustment. I know that we want to, on the grievance procedure, you state you want it in your proposal to be fair, expeditious, and I don't know what orderly adjustment really means. Does that just mean administration of it, or if you can just...
You know, I kept it in there because it's in the current contract.
I saw that. I hadn't realized that, but.
You know, what I think it harkens back to is, you know, the old days, before we had, and I'm just not talking just about the city of Corpus Christi, but labor relations generally. Before we had, you know, the whole idea of collective bargaining and resolving things in a fashion that was very expeditious. You know, you had wildcat strikes and work stoppages and, you know, violence and all that sort of thing. And so what it is it's just to assure an orderly manner for adjusting grievances under the contract. And the idea is that, you know, every time you lose an arbitration or I lose an arbitration, we don't feel like it was necessarily the right outcome. But we have to live with it.
Right.
Because, you know, and so we make sure that there's a way to resolve the grievance, that the procedure itself is fair.
Okay.
Even though we won't always all agree with the outcome.
So does adjustment basically equal resolution?
Yeah.
Is that what it means?
Yeah,
Okay.
it means a way to binding resolution. You know, we're not kids on the playground anymore, and we're going to fight, and the strongest person wins. You know, there's a contract. It has meaning when we disagree. There's a way to resolve that dispute in a way that's fair and in a way that is non-violent. Sounds.
No, I'm.
You understand what I mean?
Right.
It's fair.
A professional manner.
Yeah, right.
Okay.
Just like when we litigate, we resolve things in the courthouse. You know.
That's right.
We don't always agree with the outcome, but it's a way of resolving differences that society has come to recognize as an appropriate way.
Okay, so I just wanted to make sure, okay, so adjustment basically means the resolution of these grievances.
Right,
Okay.
that's right. You know, grievance, and you'll notice, I'm sure you'll have questions about this, that I put in there provisions that allow the city to file grievances too.
Yes.
The city shouldn't have to haul off and go to court when they feel like that the union is violating the contract.
And this proposal, as I read it, is exclusively for contract grievances, is that correct?
That's right. You know, if you look at section 1B, the exclusions, that's really just something that came out of another provision in the current grievance procedure. It's not intended to apply to disciplinary matters, promotional bypasses, discharges, promotional exam appeals. This is a method of adjusting grievances concerning the contract itself.
Okay. Because, you know, I guess the city has policies that allow you to, I know that there's going to be a non-discrimination part of this provision, but I'm talking about the city has policies with regard to if, you know, an employee feels that they're being discriminated against for purposes other than what's included in this contract, or harassed, or, you know, different things like that. So I just wanted to make sure that those grievances or those complaints would still find their way through the proper channels as they have already done, and that this is separate and apart. This is only to administer this particular agreement that we're working on getting.
That's right. If
Okay.
my complaint is that you're violating my rights under a city policy that's extraneous to this agreement, then this grievance procedure would not be used to resolve that complaint.
Okay.
There's a city policy that refers to, I don't know, parking privileges. Well, I can't file a contract grievance about that under this procedure unless I can point to a specific right given by this contract. Now, I don't want to mislead you. The proposals that we've made, there is a maintenance of standards provision. So if you've always provided free employee parking and you suddenly say, no, we're going to make employees pay for parking now, then we might be able to file a grievance on something like that under the maintenance of standards provision.
Okay.
Okay, but But this is limited to resolving contract disputes. And by contract, I mean this agreement.
Okay, and then as you referred to earlier, I see that one of the major changes that has been incorporated into your grievance procedure as proposed, which is different from what the last contract was that now the city is included as somebody who can grieve with regard to a contract issue. Is that correct?
It is. The only thing I'm balking at is you're saying it's a change. It's not clear to me whether or not that in fact is a change. I mean, it's true here, as I'm sure it's true everywhere else. 99 out of 100 grievances involve employer or association complaints. But I do think that the rights that are given to the city in the contract, that if they feel like the association is violating those rights, that the city should have the right and the ability and maybe the obligation to file those complaints under the contract procedure. So the good thing about that is you get a really expeditious ruling about those things. Arbitration can be completed in a matter of months. You know, sometimes it takes a matter of months to get a hearing in court. I mean, there's always, you know, temporary relief, etc. And the inevitable appeals in court. So that's, you know, what's going on there.
But in the last contract, the city wasn't a part of a party that could actually file a grievance.
You know, I hear you saying that, but if I look at the grievance procedure itself, on page 29 of the current agreement, it says, you know, the purpose of this grievance procedure is to establish an effective method for the fair expeditions and orderly adjustment of grievances, and is exclusively for contract grievances. A grievance is defined as any dispute, claim, or complaint involving the interpretations, applications, or alleged violation of any provisions of this agreement. So I would say that that would certainly cover a complaint by the city, or, you know, involving the interpretation, application, or alleged violation.
I think there's an exclude, the next sentence says the union or any bargaining unit member may file a grievance under the terms of this agreement.
Right, and so what that means is you've got two sentences there back to back that contradict each other. Because the two sentences, you know, on the one hand, the first sentence says any dispute as to the interpretation and application of the agreement is within this grievance procedure, and then it says the union and the employees can file a grievance. Well, that's, you know, inherently contradictory, and the reason that I think it is that way, well, really there are two reasons. Number one, this contract's been written over a period of 40 years, so things have been glommed on. Number two is, it's true that most of the time when you're negotiating a grievance procedure, you're thinking about employee and union grievances, because that's usually who files them. But there have been city grievances before, and, you know.
Okay, so would this limit, if the city had any complaints with regard to a breach of the agreement or some sort of violation of any of the provisions, would the inclusion of the city here prevent them from filing a lawsuit in court?
I would argue that, just as you would argue that the existence of this procedure would limit us to filing a grievance rather than hauling you into court if we alleged a violation of the terms of this agreement.
Okay, so
again, it's limited to violation of the terms of this agreement. I mean, if you say we're violating the collective bargaining statute or our duty to bargain in good faith, or something that's, you know, outside of this contract, of course you still have a court remedy.
right, okay.
Of course, in every collective bargaining agreement that I negotiate, I try to give the city as few rights as possible. So you don't have to grieve much.
What kind of grievances would the city file under this, since when we're negotiating this contract, we're negotiating for wages, hours of work, and conditions of employment for the members of the bargaining unit.
You know, where I can't remember ever arbitrating a city grievance, where I've seen cities, you know, initiate grievances, and usually they get resolved informally. Usually have to do with the interplay of the obligations that the association undertakes with regards to its membership. For example, you know, we're not submitting appropriate forms and then demanding that the city nonetheless deduct dues, or we're not, you know, something of that nature. We had a dispute in another city a few years ago that had to do with exactly with that, a member of the association who had been kicked out of the association nonetheless wanted to have dues deducted, and the association was demanding that they not deduct dues for this person, and the city felt like the association was violating the contract because that person had submitted a dues deduction form.
Mm-hmm.
We were able to resolve that informally before it got, you know, very far down the road. But that's an example of the kind of thing that I've seen grievance type issues raised by the cities. If the city, for example, felt like the association, in contravention of its agreement, was discriminating against members of the bargaining unit on the basis of their non-membership, the city certainly could raise that as a grievance type issue. So, you know, things like that. It's usually the interplay of the relationship between the association, the city, and the members is where those issues come up, and where I've seen it.
You know, you're the first person that I've talked to that ever thought that the last contract gave the city the right to grieve.
Well, you know, I mean, it was contradictory, but I do think that, you know, to the extent that the contract does give the city rights, and sometimes it does, I mean, there are obligations that the union undertakes within the walls of this contract. And quite frankly, I don't understand why the city shouldn't be allowed to grieve violations, you know, if in fact they think that the union's violating the obligations it undertook. And, you know, I'm not suggesting to you that we undertake as many obligations under this document as you do, but we certainly do undertake some important ones.
Okay. That answers my next question, which I listed. That was why would the city be included in the grievance procedure? It's not part of the bargaining. We just discussed that.
Mm-hmm. And, you know, and I put in a whole different grievance procedure, you know, for a city grievance, because obviously some of the steps that we ask members to go through don't make a lot of sense.
Okay. What steps did you make sense in the last?
Informal resolution.
Okay.
You know, for example, you know, if the fire chief has a complaint about the way the union's doing something, he doesn't really have a supervisor he
Oh,
can
I
go
see. I know what you're
to
saying.
try and informally resolve, so.
Okay.
And also, he shouldn't have to go to the association grievance committee. Oh, gee, we don't think that's a valid grievance,
Right.
so we're gonna not process that further.
Okay. On, let's see, it's section 2A, Association of Firefighter Grievances. These are the questions that I have here.
Okay.
Does the union and or the firefighter have the ultimate discretion, ultimate determination on whether an issue is a class action?
Yes, I mean, they would designate something as class action. You know, where this comes up is, and I think it may have come up here, is that if a firefighter has a pay issue where you've agreed to pay assignment pay for this at $50 a month, and you're not, and it turns out that, well, no, we're not paying you that $50, we're not paying anybody who's got that certification, that $50. Well, then that lends itself to a class action grievance, and we shouldn't have to name everybody. Now, the association presumably, could file a grievance on behalf of everybody, but, you know, sometimes it's just a class action
Okay.
grievance. I don't see there being a whole lot of class action grievances, that they're gonna happen when the city would do something that would, you know, affect everybody equally, generally.
Well,
Or at least a whole group of people. And maybe, and you know, I mean, I'm not wedded to the term class action because I
Okay.
know that's kind of like fraught with overturns. I mean,
Right.
group grievance
Okay.
might be. You know, firefighter A files this on behalf of a group of similarly affected firefighters. We think of that as a class action, but, you know, it could be a
Okay.
group grievance too.
I don't know if this is addressed, it didn't seem to be addressed in this proposal, but with regard to class action, what happens if an issue is determined by the city to affect more than one firefighter and the, you know, the union and or the firefighter, it's probably more the union at this point, doesn't designate it as a class action.
I think that's a fair point. You know, the city says, well, you know, firefighter A's filed this grievance, but really that affects all firefighter ones.
Right.
So why don't we just do this on behalf of all firefighter ones? And the union says, no, we want it just to be
The individual.
the individual, so that if he loses his grievance, we get another kiss at the pig somewhere down the road.
Right.
Well, then, I think it's, you know, I think that's fair for the, you know, the city to say, no, let's resolve this once and for all for everybody. So make me a counter on that. I'll be
Okay,
glad
I was just
to.
wanting to make sure that I understood it and that, you know, because I think that that's an important element that's missing. Because we have had an issue where we have had multiple grievances on the same issue but filed individually, and they weren't brought into as a class action.
It's a problem
And there was
because,
I mean, there's duplicate costs, there's duplicate grievances, you know, when we could all take care of that at once, you know, and,
Yeah.
and resolve it. And we even went to an arbitration on one of them, and then there, you know, there was a question as to whether the others were gonna continue, and the city had no control over that at that point. And not that we wanted to control whether you had a grievance or not, but we, you know, if it was a class action, then it was something that had already been taken care of, and we're going through unnecessary steps and unnecessary costs. So that's just one of the things that we need to address in looking at the grievance.
I hear you, but, you know, my response to that is, although arbitrators aren't bound by res judicata to the same extent that courts are, by and large, most arbitrators, if you've had a resolution of what a contract, in a contract interpretation grievance, if you've had a resolution of what it means, it becomes a lot harder for another arbitrator to ignore that, unless
Right.
they just think it's really, really badly reasoned. I mean, just
Right.
in the same way that, you know, a Corpus Christi Court of Appeals decision doesn't bind Amarillo,
Right.
but Amarillo will still be guided.
Right.
It's the same kind of principle. So,
And I understand the guidance and that we use that in arbitrations, but those arbitrators like to send separate invoices.
That's right, and, you
And they
know-
like to eat at nice restaurants.
and I like to join them.
Right.
Correct, Richard?
Is this a
So,
great time to
anyway, that's just an issue that we're gonna address and that we wanted to point out.
No, that's fine, that's
Okay.
fine. I mean, you know, that's legit. We would certainly consider that.
Okay. Another question I have on the Union Grievance Committee, because here we have that at least the firefighter grievances are sent to the Union Grievance Committee,
Mhm.
and the Union Grievance Committee goes through a process by which they determine whether a grievance is viable and continues. We would like to know, number one, what is the Union Grievance Committee? What is it comprised? Who is it comprised of? And what kind of parameters and process do they go through in order to ensure this? Because, you know, that's kind of a checks and balances kind of deal. We rely on the union to do that, but where does the city come into play? Because then once it goes on, I mean, once the Union Grievance Committee says it's good, let's go, the process continues, and the city's gonna have to go through it one way or the other. So.
That's right.
We don't understand what the Union Grievance Committee is. We would like more information on that, especially if it's gonna be part of a proposal that we're gonna be considering. And basically, we just need to figure out what is that process that it goes through.
They're kind of a gatekeeper. Your average firefighter, especially the way the contract is currently worded, doesn't necessarily understand what a grievance is, when one should be filed, when it shouldn't. Go back to the parking space. Hey, I've always been provided a parking space, and now they've taken it from me. I want to file a grievance about that. Well, the association is going to have to pay for that arbitration, just like the city is.
Mm-hmm.
And so the association doesn't want to advance grievances that they know are meritless. Now, they may want to advance grievances that you think are meritless, but by and large, they steer employees away. So if this employee comes and says, hey, I want to file a contract grievance because the city is violating city policy number A1, you say, well, that's not a contract grievance, so we're not going to process that. So they're really fulfilling the role of a gatekeeper. Now, there are two ways to do that. You know, one is to have an association grievance committee at the start, and that's the one. And the other is only the union can invoke arbitration of a grievance. And so if we don't have an opportunity at the outset to perform that gatekeeper function, we're probably going to do it at the arbitration stage. But in the meantime, whatever supervisors are in that grievance stage are going to have to have gone through something that maybe we could have been prevented at the outset. So it really is using an association grievance committee can be kind of a win-win. Again, I'm not trying to hide anything from you. There are going to be times we think it's a grievance and you don't agree. That's what the arbitrators are for. But we can stop a lot of stuff that employees think are grievances that we know just aren't.
Okay. And so the union grievance committee is comprised of all union members, right? It's all.
Yeah. I mean, all of the members of the grievance committee are union members, and they, I don't know what the selection process is. It varies from local to local. I don't know how Corpus picks them, but it's a standing union committee usually. And they exercise that gatekeeper function. Of course, they do that in light of their duty of fair representation. And the duty of fair representation requires them to administer the contract fairly without regards to member or non-member. So, a non-member has just as much right to file a grievance as a member does, and the union has to act on legitimate non-discriminatory bases in deciding what grievances do and do not go through the grievance procedure. And presumably, that would be, that what I was talking about earlier, the interplay city association member. If the city feels like the union is violating the non-discrimination provision, the city can file a grievance.
What happens if a member of the bargaining unit, or whether they're a union member or not, files a grievance with the union, and then they feel the union grievance committee, who's the gatekeeper, and then they feel the union grievance committee says no, this is not a viable grievance, and then that person, whether they're a member or not, feels that
the union made the wrong call.
The union made the wrong call. Where do they get to go through this grievance procedure in another way, or is there?
They don't get to go through this grievance procedure, but what they can do, and I've had this happen several times over the years, is they file a lawsuit against the union and the city, and it's the duty of fair representation lawsuit. The most common example is a firefighter who is discharged, and the union decides, because in a lot of my units, everything goes through grievance arbitration. They don't have that separate hearing examiner procedure like you do. But the firefighter, they don't process the termination grievance, and the firefighter feels like that they were fired unjustly and that the union essentially colluded with the city to prevent them from getting their day in court. They would file a duty of fair rep claim against both. And they have to prove two things in that case. They have to prove, A, that they had a viable claim under the contract or whatever it is, and B, that the union, for whatever reason, failed to exercise their duty to represent them. And, I've had, over the years, in a lot of contexts, even duty of fair rep grievances where the union blew a timeline. although the standard is pretty high on blowing a timeline, you know.
Okay.
You have to show negligence at a very high level. I had a really bad case years ago that I won't bother you with on camera.
Okay.
So that's, they do have rights there.
Okay, well, and I think this brings up a good point as to, when we're talking about the Union Grievance Committee being the gatekeeper, and we want to somehow insert checks and balances in here. Say a bargaining unit member does file a lawsuit against the union and the city for something that the Union Grievance Committee, somehow they're alleging that they failed to do, okay? There's liability upon the city there, but the city has no way to, I guess, no checks and balances, and to make sure that the Union Grievance Committee is following the parameters or the obligations that they have committed to within the agreement. Do you know where I'm going?
Yeah, sometimes yes, sometimes no. But I mean, you do have options. For example, let's say that it was a simple case where the union blew a timeline, so the city is within its rights to say, well, your grievance is dead because you blew the timeline. Okay? I mean, that's the way your current contract reads. Well, in that case, then if the employee says, well, man, I just lost $1 million because I had a rock'em sock'em pay claim, then the city can always, the city is still on the hook if they've got a legitimate contract claim, potentially. But the city and the union are going to fight about who owes what, but of course the city can always waive the timeline, and that happens sometimes. Hey, we're not going to enforce the timeline, let's go ahead and give this guy his day in court and see what happens. So, and these are rare cases. Over the course of my career, I probably only, and I sure don't want to say on camera how long that's been. I probably have defended less than 10 duty of fair rep cases against private and public sector unions. They're rare.
Okay.
And so we don't want to, we could spin our wheels a lot trying to protect ourselves against liability that almost never happens.
There's always that one time.
Well, and I'm telling you more than you want to know, this is an issue that rankles with me a little bit. Some unions, I'm not talking about Corpus here, but some unions engage in defensive grievance, there's, lean over real hard in favor of the employee and arbitrate some grievances that you don't think very much of because you're afraid of a duty fair rep suit. Because the danger is not that you'll lose the duty fair rep suit. The danger is you'll have to pay your attorney to defend against it. And God knows those unions hate that.
In theory.
In theory.
In theory.
Yeah. So that's, I really believe that if you believe that something is BS, that's technical legal term, that you ought to be able to call BS on it. And so I'm, I tell unions do what's right. But at the same time, everybody, I think, in these modern times engages in a little bit of defensive.
Okay. Did you have a question?
It was really more a technical question. If the issue is that the union is not fairly representing its own member, or someone that's representing,
non-member.
or non-member,
Yeah, because we've got a
then
duty to.
why is the city subject to the lawsuit? Because we have no control over that situation.
Oh.
Like I said, it most often occurs in a wrongful discharge claim. And in that case, remember that the first thing that the employee has to prove before they can even get at the union, they have to prove, well, I really was wrongfully discharged. So the city did engage in misconduct. They just got a get out of jail free card because the union blew a deadline.
But on a straight grievance of some provision.
On a straight grievance of some provision, let's say a pay provision, duty of fair rep, I can't think of off the top of my head where we've had a duty of fair rep. They almost always occur in the context of discipline or discharge, but usually if it would happen, it would be, blowing a deadline, and that doesn't mean still that the city didn't violate the contract. They just got to get out of jail free card. Most lawsuits against unions for duty of fair rep, of course, I won't say most, but a goodly number are probably brought by non-members who feel like they're not being adequately represented.
I mean, I
And
imagine
in
most
that
of those
case-
are economic, otherwise they probably wouldn't have the damages required to even file a lawsuit.
Right.
So
It's usually-
It's usually economic.
Yeah, and, you know, in that case, they're always alleging there was a violation of the contract, you know, of some sort. And so they have to prove that the city or the employer actually did violate the contract to have a claim against either the city or the union. And because of that, the city is never gonna be punished without having done anything wrong. Okay, I mean, is that? And sometimes that's where we get in trouble, believe it or not, is, hey, we've looked at your claim and the city did it right here. And so we're not gonna file this grievance, you know, and then you and I both may end up on the wrong end of the DFR claim. But, you know, we're gonna pretty much stand together because we don't think we did anything wrong. And those are kind of fun because then you're actually on the same side as the city. It doesn't happen too often.
Okay, well, and then I had questions on that same section. I was asking whether it was notice to the fire chief at the initial filing of the grievance, but that's addressed in a later section. And whether there was a timeline, and then I found a,
Yeah.
it was a 10-day timeline.
Yeah, 2B, the Association Grievance Committee, when they get the grievance from the firefighter, they're supposed to give notice of receipt of the grievance to the fire chief within 3 calendar days. Hey, we got a grievance, we're giving you notice we got a grievance from
Mhm.
Johnny Stobbs.
Okay.
But why don't they give him the actual grievance at that point? Because, quite frankly, a lot of firefighters need the assistance of the Association Grievance Committee to really make sure that they, you know, meet all the requirements, that they talk about the factual situation, identify the parts of the contract, requested relief, you know. So what we get sometimes from the firefighter is a mess, and we want to make sure that they don't get booted out just because they're not sophisticated enough to do it right.
Okay, so at the initiation of a grievance by a firefighter or a member of the bargaining union, the chief gets an initial just notice, not an actual copy of the grievance.
Right.
The copy of the grievance is sent over to the chief once it's passed. and
Determined to be a
approved by the-
valid grievance.
Okay.
And, you know, that 3-day period, you know, is really the association, you know, a lot of times what happens, the association says, you're talking about a city policy, you can't file a grievance under this, so we don't even need to bother to write it down.
Okay.
Well, the chief still, you know, so if in 3 days there's something worth writing down, the chief gets notice. That way you can enforce timelines. But at the same time, you know, we utilize that time period to weed out a lot of stuff.
Okay.
Believe it or not, as many grievances as you may feel like we file, we ward off others, so.
A lot.
A lot, yeah.
Is there a, like a chart kept of?
I don't
of
think
those?
so.
No.
You know, probably not, you know. I mean,
And I'm not
nine
looking
times
for
out of 10, the
names or anything, but I'm really interested to see just the numbers as to what goes into the grievance committee and what comes out. That would be.
I don't think we have that kind of information. I mean, a lot of what happens is a member approaches the union president or a union officer and says, hey, I think my rights have been violated, blah, blah, blah. And, you know, the union officer says, no, that's not a violation of the contract, or, you know, for whatever reason, that's not a valid grievance. And the matter ends that way. It may not even get as far as like the full committee.
Okay, so it ends informally, is
Yeah.
what you're saying. Okay.
And it ends quickly. And believe me, we really help y'all with that gatekeeper function. If everybody that wanted to got to file a piece of paper, we'd have a lot more pieces of paper.
I'd be asking for a raise.
I'm asking for a raise anyway.
Yeah.
Good luck with that.
Yeah, I know.
Okay.
Hope guys last.
Submit a proposal.
Wait, we look at your
Now,
paper and tell
and-
that's not valid.
And you said. Do you want me to file a duty of representation?
Hey, absolutely.
For you?
Represent
City grievance.
Okay, and the city grievances, do they go, let's see, the way it's Does it go to the union grievance committee? Because I see.
Not at all.
Okay.
They file it with the association president.
Okay.
And then, the association president gives a response, and then the city manager can arbitrate. And I think the timeline for making the arbitration decision is exactly the same for employee and union grievances.
Okay. Now, there's a 10-day timeline, I believe, in that section, I think 3B. Well, let's talk about section 3A, the informal attempt at resolution. My question on the timeline is, we have that informal step at section 3A, and then we have section 3B, which says that they must, a firefighter who feels that they may have a grievance has 10 days to file such with the committee. Is that correct?
Yeah, once they knew or should have known of the facts or events giving rise to the grievance.
So does that 10-day timeline include that step one informal attempt at resolution? Is that 10-day deadline include trying to informally?
The way I've written it, the 10-day deadline is not extended because
Okay.
you're trying to informally resolve it. Okay? You really need to do that. And the reason I made the informal resolution, the reason I did that and the reason I made the informal resolution optional is because there's a lot of grievances, that the supervisor can't do anything about.
Right.
And those types of grievances, if it's a pay grievance and we feel the fire chief, him or herself, may not have the ability to correct that. So it doesn't make any sense to have to run it by the supervisor.
Well, you give me a good segue into my next question, because we talk about just supervisor. What ranks are covered by the supervisor, and how far up the ranks can you go in order to try and informally settle this before you arrive at the fire chief? Because sometimes if your supervisor is, I think they call them house captains. Is it a house captain or a captain?
Mm-hmm.
And he doesn't have the authority to deal with the issue being brought before him. The next step is to go above him. How far?
Well,
What ranks, I guess, are entailed in that supervisor before you get to the chief? Does that go all the way to the assistant chief? Does that allow for that?
Normally, well, there's a lot of answers. I mean, I don't like the whole informal thing because I don't think it works much. But it's in your contract, so I left it in there. But informal resolution is just, whoever does have the authority. I mean, right now, your current procedure is whoever your supervisor is, and that's usually going to be the captain. I mean, for your firefighter 1 or firefighter 2, their immediate supervisor is going to be their station captain. So they're going to go to that station captain, and if it's a violation of the contract, a lot of times that captain has no authority whatsoever to remedy that situation. That captain could choose to go up the chain of command at that point, and may or may not do so. So that's why the way I did it, I didn't have it for filing the grievance or anything. If you really want to focus and encourage informal attempts, and you want to increase that 10 days to 15 days or 20 days or whatever, I'm fine with that. But no, I'll tell you later.
Yeah, well, and this is the concern, is that if you limit it to just a firefighter going up to their captain, and the captain doesn't have the authority, but say a battalion chief does, or an assistant chief has the authority to fix whatever problem it is, whether it be a scheduling problem, or somebody didn't get paid out of assignment pay that they were supposed to have gotten, which happens every now and again. Everybody's human, and we've got these computer programs that have bugs in them and stuff like that. But if the captain doesn't have the authority, but it's somewhere within the ranks before you get to the fire chief, and we want to try and push that forward so that things that could get resolved informally, I think it has worked in the past, from what I've heard,
And truthfully, I mean, that's where you see it. A firefighter goes to the association president and says, I got this problem. And the association president says, wow, I didn't know that was going on. That violates the contract. And then, a lot of times it's the association president or another officer that goes to the, whoever is the offending party and says, hey man, this violates the contract, will you stop doing that? And if they say yes, great, problem resolved. But so many things that end up in, contract grievance arbitration are like policy matters that really only the fire chief is the decision maker. And on those, the association president might go to the fire chief and say, hey, chief, you really can't do this. And the chief will agree sometimes and not agree others. I don't mind, and I certainly understand the city's desire to have as many of those informal resolutions as possible. And so there's a balance between trying to informally resolve things on the one hand and expeditious handling of problems on the other.
Right.
And so, we can.
And we're not trying to
Yeah.
compromise the efficiency or how expeditiously it gets done. It's just, if there's like a small step that may be missed that could resolve the whole thing, we need to figure, that's
Yeah.
one thing. How can we figure out a way to get it in there? So.
That's fine, and what you could do is have a 30 calendar day deadline for filing grievances, and urge the parties to take whatever steps to informally resolve during that 30-day period are possible. But at the end of the day, a lot of the things that end up going to arbitration aren't things that a captain can fix. It's really at the fire chief level normally. And sometimes not at the fire chief level,
Right. Yeah, there are some of those grievances.
And the tension that we have there, on the one hand, we don't want to be sitting there trying to informally resolve something and then have the city come back and say, you didn't file this grievance timely.
Right.
So.
And that's not the, right, I
Yeah, I know.
understand. I understand. Those timelines can be tricky to make them all work,
Yeah, they really can.
It really,
They really can.
because there's, every now and again, you get a factor that you didn't consider that kind of comes in and blows everything.
Mhm.
But that's not our intention. Our intention is to try and figure out an efficient way that gets the process done quickest and finds the quickest resolution. Okay, on the action by the fire chief, step 3 on a firefighter grievance, it says that a chief may but is not required to conduct a grievance meeting with the grievant and the association representative. I'm assuming this is just to meet with them informally, and if they don't do it because of time constraints or et cetera, would that be used against the city or the chief in any way?
No, it shouldn't be. I mean, it's made optional, so it shouldn't be held against the chief. I mean, as we were just saying, there's some things the chief, him or herself, doesn't have the authority to resolve. If they, understand what the request is that's being made, and they can't resolve it at their pay grade, it really doesn't make much sense to have a meeting.
Okay.
If it's a policy issue. On the other hand, if for any reason they don't understand exactly what's going on in the grievance, and getting more factual information from the grievant and our representative would help, by all means have a meeting. Because the goal is always to resolve it at the lowest level possible.
Okay. And there's one also for the city manager, so I'm assuming that would be the same intent, that.
Right. If the city manager, if it's a budgetary matter and the city manager says, I'm not doing that unless I understand what you're asking, I'm not doing that unless an arbitrator makes me, they don't have to have a meeting. Can't be held against them.
And I don't know if you know, but we have employed, even though it wasn't called for in the contract or the agreement, we have employed informal meetings at separate levels just to narrow down the issues, and sometimes it helped and sometimes it didn't, but we tried.
Yeah.
So, and it works.
Believe me,
Communication is key.
I know, I'm all for dialogue. I mean, keep talking.
Okay, and on the invocation of arbitration, I think you stated earlier, it's the union's the one who makes a determination whether to go to arbitration.
That's right.
And is it, who on the union, is it the union grievance committee?
It's gonna be the union grievance committee, yes. And, you know, if they've submitted, and it may seem confusing, why do they get it twice? Well, they got it at the start, well, this is a valid grievance. But the grievance procedure itself is a learning process. If the fire chief or the city manager said something in their response that for the union clarifies it in their mind that it's not really a valid grievance, then they don't invoke arbitration, and it dies with that final response.
Okay. So on that same thought, with regard to, we wanted some information as to what kind of procedures or parameters are used when they initially review these grievances. We would like information on the process that they go through to determine whether it should go to arbitration.
Well, it would be very hard to describe the process because it is going to vary depending on the nature of the grievance. There are so-called contract interpretation grievances. There are disciplinary matters, very different kind of processing. But the you know, the steps that a grievance committee should undertake, you know, is, let's say a contract interpretation grievance, look at the contract language, try and understand as best they can the facts, and, you know, in some cases even look at bargaining history if it's available. It'll be available to you this time. And find out if they think it's a valid grievance. And, you know, you have good grievance committees and bad grievance committees, I guess, just like you have good, all kinds of committees. But that's the kind of process they should go through.
Okay.
You know, I mean, the association, when it arbitrates a grievance, is committing itself to paying for that arbitration. And for that reason, you know, they should use the arbitration procedure, you know, cautiously.
Okay, then moving on to section 4A, which is step 1 on the informal attempt at resolution for a city grievance. It says that we would try to informally resolve a grievance to the appropriate association officials. Now, would that, who would those officials be? Would that be the union grievance committee?
Well, you know,
Is it
90%
just
of the
depend-
time it's probably going to be the association president. I
Okay.
mean, that's going to be the person you talk to. But again, you don't have to. You know, it says you should, where appropriate, seek to informally resolve grievance with the appropriate, you know. And quite frankly, like I told you before, on the few occasions where I've seen cities claiming contract violations, they have done exactly that, gone the informal route first.
Okay.
And we've usually been able to work it out. We are reasonable people.
Okay, and again, that 10-day timeline that's as proposed would include the informal attempt as well as the time to file the grievance.
Right,
Okay.
and you know, I think I use 10 because 10 is what's in your contract now.
I think
I
so.
certainly can be persuaded that we ought to increase that a little bit. But it's knew or should have known, you know, and of course you also have the concept of continuing violation. You know, if you're doing something wrong every single payday, just as under the FLSA, each payday is a separate violation. You've got a continuing violation there. You know. And I'm sure you noted this too, but I haven't provided a form for E1 and E2, but I assume that there would be forms very similar to the ones that the
Right.
union members use.
That's what I had assumed as well, and I was more focused, I guess, on the intent of what we're trying to get to before we start talking form. On the arbitrator selection and setting the hearing, which is section 5A.
Mhm.
Who makes a determination on whether to choose the AAA or FMCS? And why are we, what's the benefit of using those over private, I know they're the two big arbitrator providers.
Well, you have to get your list of 7 neutrals from somewhere.
Yeah.
The reason AAA and FMCS are both in here is because it's in your current procedure.
Okay.
You know, I can tell you that it's cheaper to use FMCS normally than it is to use AAA. But AAA is probably, you know, the larger organization now. So I don't know that I have a lot of heartburn about, and as to who picks it, that's not clear really from the procedure. But I mean, we could choose to go with one or the other. It doesn't much matter to me. A lot of the arbitrators, especially the ones that have been around a long time, are on both sets of lists. So.
Yeah, I've had the experience of trying one or the other to try and get some new names, and we see the same names.
Yeah, you really do. You really do. And of course, all the arbitrators, they strive to make sure their names are on both of those so that they can get on as many panels as possible.
Okay, and then you proposed, right now, I guess the way that it's done with regard to striking for arbitrators is that there's a list maintained by the Human Resource Department, and it alternates.
Oh, you mean about who has to strike first?
Right.
And if you want to keep going with that, I'm fine with that. The thing is that different people are affected by grievances. You know, I mean, the first grievance that comes along the pike, employee A is affected. The second grievance that comes along, employee B is affected. So,
Right.
Really, why shouldn't one have just as much chance to have the second strike?
Okay.
Would, you know?
So who's going to provide the coin?
You know, I
Look
literally-
here, Carlos already has one.
Yeah, I literally have, been on the phone with the attorney for the other side saying, I'll trust you to flip the coin
Yeah.
and tell me if it's heads or tails. Like, how do you flip
If
the
you
coin
can
when
find
you're
a-
in a different town?
If you can find a coin nowadays. But just make sure they haven't been to Las Vegas right before or something
Yeah,
like that.
exactly.
Come back with the two-headed coin. Okay, let's see. On section, I have to look at the sections. Section 4, C. Oh, I'm sorry.
5C?
Actually, I'm on section 5B.
Okay.
Arbitration, hearing, and decision. There's a third bullet point. It says each party shall be responsible for the cost of the attendance of its witnesses at a contract grievance hearing. However, on-duty firefighters needed by either party as witnesses will be released from duty for the time needed to testify without loss of pay. Is that?
That's a change from the current contract.
That's what I was gonna ask, so, okay. So if they're on duty and they're called as witnesses by either party,
They're released from
still gonna
duty just
release-
long enough to testify.
okay.
And that's all. I mean,
Would somebody have to cover them?
I don't think necessarily. I mean, firefighters do this all the time. I mean, the whole engine goes down and they're, they've all got their walkie-talkies or radios or whatever. It's like, if they have to, if somebody is picked for a random drug test,
Right.
they're called down while they're on duty. Well, the whole crew just goes with them down to the lab. And that way they're ready to go at a moment's notice if they're all called out.
Okay.
But, so the idea isn't necessarily that the city's gonna have to hire a replacement person.
Okay, and I just didn't, know how that would work, and I just wanted to ask questions about that. Currently, how, I can't recall how it is currently. Y'all have to get off duty?
I think probably I don't know what's happening.
Yeah,
to be
okay, I'll
honest
look
with
at
you.
it, I'll look at it. I know I looked at it earlier, but I just don't remember.
What's the question?
What happens when you need an on-duty firefighter to testify?
He usually goes and just testifies, depending on where he's at and.
But
how
does
much
the city
manpower.
hire a relief person?
I've never known him to hire one.
Okay.
I think I just did it 3 or 4 months ago.
Yeah, I think in the past, it's been like you described, they'll just put that
Yeah.
piece of equipment out of service for an hour, hour and a
Okay.
half.
Okay,
So, unless the hurricane blows in, then all bets are off.
okay. Then we shouldn't be in here hearing that.
Unless you're out of town already.
I'll be in that third lane on the road that's been converted there.
That'll be not moving.
Yeah.
Okay, and then on the arbitrator's authority, we're talking about, oh, I'm sorry, it's before that. I'll put my question down here. There's somewhere in here that says that, you know, the arbitrator, oh, here, on the arbitrator's authority, he or she is only going to determine the issue submitted to them for arbitration. My question is, are you thinking with your proposal that the notice of the issues to be arbitrated is going to be served by that initial grievance that's filed? It's going to be limited to whatever is in that form?
Yeah, I mean,
That's-
you know, it often happens in arbitration that the parties can't agree
What the
as to
issue
the
is.
statement of the issue.
Right.
And if that happens, they normally commit it to the arbitrator to frame the issue. That happens a lot. But this language is in the current contract, and all I think it really means is the arbitrator is not allowed to go outside the scope of, you know, what the parties have been grieving.
Okay.
You know, arbitrator can't go out there and say, well, I know y'all are talking about this problem, but I really think it's this other problem, so that's what I'm gonna decide. That they really kind of confine themselves to the issues that they're alerted to by the parties. It would not prevent the arbitrator from doing what you're familiar with, which is, okay, you say the issue is this, you say the issue is that, do you agree to let me frame the issue?
Okay. And usually that's what we try to do at the very beginning if we haven't stipulated to already.
Mhm.
Okay. Those are all the questions I have for Article 25.
Okay.
We're gonna move on to Article 24.
Article 24.
We're gonna move on to Article 25, appeals from disciplinary action.
Okay.
Now, is this article meant to apply to, I was gonna ask what disciplinary actions are covered by this article, and as I read through, I found that demotion, suspension, and discharge, or also known as indefinite
Indefinite.
suspension, are what are subject to this, and I just wanted to clarify that.
That's true,
Okay.
that's true. You know, promotional bypass, I've made a separate article on that. We haven't gotten to the promotion article, but I assume that it'll deal with promotional exam appeals.
Okay,
Or if it doesn't, the Civil Service Act certainly does.
right, I think in
But
fact.
this is not for those.
Okay, and so this is going to be separate and apart from anything that the Civil Service Commission has purview over, because right now, I think that pursuant to what you're proposing right now, I think the promotional items and the promotional bypass, well, not the promotional bypass, but the promotional issues are overseen and heard by the Civil Service Commission.
Yeah, and I haven't really delved into the promotional procedure yet enough to know if y'all have supplanted the Civil Service Commission on promotional bypass appeals. Some units have. Austin comes to mind as a group that the Civil Service Commission procedure wasn't working for them, and we did negotiate an alternative. But for the most part, most units leave it with the Civil Service Commission.
Okay. And here under Section 2A, allowable suspensions, there's two kind of things intermingled in here. It says what a chief may, how long a chief may suspend somebody, but it also says how long a chief may suspend somebody pursuant to a written agreement.
Right.
Okay.
You know, under the Civil Service Act, you can suspend from 1 to 15 days and indefinitely suspend, which is discharge. You can't, and then by agreement, it's 15 to 90 days.
Okay.
So your current contract actually allows involuntary suspensions up to 30 and agreed suspensions from 31 to 60.
Okay.
We've increased the agreed suspension to the Civil Service Act limit of 90. We've kept that increase from 15 to 30 on the involuntary
Okay.
suspension
And so-
with right of appeal.
So any suspension at all, whether it be below 30, above 30, any suspension is appealable? Is that
No,
correct?
no, no. 31 to 90 is not appealable because, you know, the firefighter
Oh,
provides
okay.
written agreement accepting the suspension and waiving any and all rights to appeal the agreed suspension. So,
Okay, so the fire chief, without an agreement, if he was gonna go forward, the most he could suspend somebody is for 30 days.
that's right. And
And
if you
so
want to counter
30
that with something else, you certainly can.
Okay, I'm just trying to make sure
Yeah.
that I understand it and I get it straight in my notes in my head. And then any suspension from 0 to 30 days without an agreement is gonna be appealable under this proposal.
Mhm.
Anything from 31 to 90 days will not be appealable because that can only be subject to an agreement.
Right, if
Okay.
if the chief says, hey, will you accept a 60? The firefighter says, no, I won't, then the chief is limited to doing 30 or firing.
Okay.
And the firefighter who rejects that 60, you know, puts the chief to that choice, and the chief may choose to fire.
Okay. And then, the allowable appeals under section 2B, that's what's allowed by this specific proposed article.
Wait, allowable suspensions, you mean?
No, appeals. On section 2B, it says a discharge or indefinite suspension does not create a vacancy in a promotional position until all allowable appeals of the discharge decision are exhausted and the discharge is final.
Right, and that's in your current contract too.
Right, and I just want to make sure that, and this is the time to figure out what all these words means and what these provisions means, so that there's no ambiguousness between our proposals and we know what the intent is. But the allowable appeals are what's proposed by this article, and my
Right.
concern was, does something, you know, if we go through all this and then a firefighter decides to file a lawsuit anyway, so, you know, outside of the appellate process, would that be considered an allowable appeal also?
Not really. I mean, you know, under the Civil Service Act, if you don't, you know, appeal to the commissioner or hearing examiner, that's it. You know, if you file a lawsuit, then of course the city would file a failure to exhaust administrative remedies, and that would be granted. And boom.
After several months, if we're lucky. But, and that's
Yeah.
why I'm asking, because this is with regard to a vacancy. And so, you know, there's nothing that anybody can do to prevent anybody from filing a lawsuit. I can go run and file any kind of lawsuit I want right now, and whether it has any merit or not. And so my concern was, and I just wanted to clarify,
Oh, you're worried about the word allowable.
allowable appeals.
Yeah.
I wanted to, my understanding here, and just wanted to clarify, is that just the allowable appeals within this proposed article? You know, because I'm saying allowable
No, it
appeals.
would be whatever appeals are allowed by law, okay? You know, I understand what you're saying. I mean, what this is really intended to address, there's a provision in the Civil Service Act that says when the chief indefinitely suspends somebody,
Mhm.
even if that person appeals it, it still creates a vacancy immediately, okay? And that's the Cox case out of Fort Worth. And so I'm sure the city, in light of that, probably asked for this provision so that they don't have to fill the position until the appeals are exhausted and they know that firefighter's not coming back.
Right.
And so, but at the same time, you know, if let's say somebody misses their administrative appeal, and you and I both know, I don't care what they file, they're not coming back, you know, we're gonna, then that really isn't an appeal that we're concerned with. Because what the city's trying to avoid is a forced
Having-
surplus situation, having, you know, fill that position and then you have to bring this firefighter back and now you've got too many.
Yeah. Well,
But that won't
I think
happen.
the worst problem that this, you know, that I would be concerned about here is having a vacancy, and we need to fill that vacancy, and we can't fill it for an extended period of time because somebody would decide to file a lawsuit, even though it may be dismissed pretty quick. But here, the federal court here in Corpus Christi is very low on judges. We have one working federal judge and a couple of magistrates that are helping her out. And so things take a little bit longer than they usually do.
Oh.
So it could be a year before we get that dismissed, and then we're sitting there with a vacancy for a year, even though, that's why I'm asking.
And you know, we don't have a dog in that hunt. I mean, this is in there, I thought, because y'all wanted it.
Oh,
But if you don't want it, if you want to be able to fill those vacancies immediately and risk the forced surplus situation, I'm fine with that. That's the way it works under the Civil Service Act.
okay.
And forced surplus isn't that bad. I mean, somebody goes on a reinstatement list. You know, the last hire, what I would say is if we want to do away with that and be able to promote immediately, what I would suggest is we come back and say, well, if then that person gets reinstated as a result of their appeal, that the last hired into that rank be the one who is put on the reinstatement list, and that the reinstatement list exists not just for a year as the Civil Service Act requires, but until that person gets their job back, because it's not their fault, you know, that they got displaced.
Okay.
But, you know, we're not.
Yeah, and I'm just trying to get clarity as to what all this means. Unfortunately, I wasn't here when all of these were previously negotiated and talked about, and it's hard to find the notes on
Yeah,
either the city or the union side, so.
This is one where, you know, I don't think I mean, you've got it one way here, and that probably was at the city's suggestion, although I don't know that for a fact. But we're certainly amenable to considering doing it the opposite way too.
Okay. Okay, moving on to section 3, disciplinary investigations and procedures. Okay. So, this article covers complaints against firefighters from the outside, from outside the department or the city as well. Is that correct?
Yeah, that's right.
Okay.
I mean,
it's kind of like an internal affairs kind of deal.
Right. Chapter 614 of the Government Code that's referenced in subsection A, that's been held to refer to both external citizen complaints and internal complaints.
Okay.
But there's a provision in Chapter 614 that says if you have a negotiated investigation procedure that you don't have to follow Chapter 614. So that is just protection for the city. We can't get dinged because we didn't follow Chapter 614.
Right. And because you're proposing this
Yeah.
to take place of that 614.
Right.
Okay.
Right.
Now, this investigation technique looks like a new provision.
You know, actually, the first sentence definitely is not. That's right out of the contract.
Oh, okay.
Will be conducted following policies and practices currently in effect. I mean, that is in the current contract.
The second sentence is what's
The
new.
second sentence is
Okay.
what's new.
If a firefighter is interviewed as part of the investigation, he or she will be allowed upon request to review the investigatory file in advance and to have an association representative present at the interview.
Yeah.
What would be what's the basis or, you know, the reasoning for allowing a witness or a person subject to the investigation to review the file before their interview?
Well, it gives them a chance to make sure, you know, I mean, obviously under the Constitution they have the right to a so-called Loudermill hearing, which is before you make the disciplinary decision, you give them a chance, you have to tell them what the evidence is and give them a chance to comment on it. And this elaborates on that a little bit and what it says. And the purpose of reviewing the investigatory file is so that they really do understand what is the evidence against them, and that whatever information they give to the chief for his or her consideration is really addressing what's at issue.
Okay. So
Firefighters are very nervous, my experience, when they get called in by the chief. That's something that doesn't happen every day, and they're, hey, you really seem to have screwed up here, and they're inarticulate, and they get confused easily. This is you don't think so?
I'm wondering their reaction to what you're saying.
Oh, I agree with you.
I've been called an idiot before. That's okay, Craig, go ahead.
We're not talking about your relationship with your wife.
Go ahead.
You know, and so it's to make it's to give them a more effective opportunity to make a meaningful response.
Okay, now, I guess I'm getting confused, is the initial interview, isn't the initial interview separate from the laudermill after the investigation is done?
You know, this is not necessarily contemplating initial interview. I mean, 9 times out of 10, firefighter comes in, starts the shift 5 minutes late. The first thing that's going to happen is the captain's going to call him in and say, "Hey man, why are you late?" Well, I don't consider that an investigation at that point. But when you have like, I don't know what do you call it here, PSI, internal affairs.
Okay.
Whatever. A lot of
I don't know.
Like, yeah, that acronym doesn't exist, but.
Okay. Well, but a lot of times an investigation becomes more formal. I mean, that little example, say, "Well, Chief, I'm sorry, I overslept, it won't happen again." That's the end of it. "Hey, if you do it again, I'm going to write you up." Something like that. That's not really the investigation that this is intended to address. This is, "Hey, we got a complaint, or you've been late 3 times, and we need to know what's going on. And we're going to do a little investigating. Now, we're going to interview you as part of that investigation at Firefighter." At that point, we're talking about something more serious.
Okay.
And so, yeah, I'm not talking about just the normal intercourse that happens between the supervisor. "Hey, this woman just, stopped by the station, Joe, and said you ran a red light. What the heck?" And Joe said, "It didn't happen. It didn't happen, Captain." And that may be the end of it.
Okay. Now,
May not.
would this proposal contemplate notice of a formal investigation to somebody being investigated?
It doesn't, because, this particular sentence doesn't, but, because what it says is if a firefighter is interviewed as part of an investigation. So
Okay.
if for whatever reason, when you have a formal investigation, you choose when you're going to interview the firefighter. A lot of investigators, they interview the suspect, pretty late in the game. So
Okay.
it just depends on the nature of the offense and the investigator, I guess.
And who would serve as a union representative accompanying the person being investigated, and what would be their role?
Their role, who it's going to be, will change from case to case. And it will depend on the severity of the, if you're looking at a termination offense, it may go up to somebody at a higher pay grade. The normal, everyday, minor offenses just be whoever the union steward is, or a union officer that can get down there quickly, that sort of thing.
Okay.
Now, what role will they have? Their role is not to interfere. If you ask the employee a question, you have the right to have the employee give an answer. Their role is more to facilitate, to make sure that the employee answers your question. I've seen employees that, because they're nervous, etc., that they say stuff that just doesn't even make any sense. It's to make sure that they clarify. I had a client once that kept saying, "I lied," when he meant to say I was mistaken. But English was his second language, and that's the way it came out for me. And I said, "Hey, you might want to stop saying I lied." So they're really there. And, if the employee gives an answer and they really haven't answered the question or haven't answered it fully, hey, don't forget to tell them this too. Because really you're gathering information at that point. You haven't made a decision. And quite frankly, before the fire chief has made a decision about discipline, is your biggest opportunity to affect what that decision is going to be.
And in the instance that a union representative who would be there would happen to step out of the role and try to answer for the employee or something like that, what kind of recourse would the city have in trying to address that?
I think the city, has a lot of recourse. If the firefighter insists on his or her right to representation, the city has the initial decision to make about, well, do we want to conduct the interview if you want a representative? And they can choose not to conduct the interview. They're still gonna have to give them their louder right at some point, you know, but they can choose not to interview at all. They can certainly say, look, you know, Carlos, you know, we actually brought Johnny down here to interview him, and you're doing all the talking. We don't like that. We need you to let Johnny speak for himself some. And Carlos keeps breaking in. I guess at some point you can say, well, look, we're not making any progress here. Let's just discontinue this. So you don't have to, you know, by the same token, I'm probably the only one old enough to remember Oliver North, the famous attorney, I'm not just a potted plant. You know, I mean, they're gonna, you know, try and involve themselves somewhat, and so there's sometimes this tension. But you know, you have the right to exert your managerial control to some extent. You know, and good union reps know that if I'm doing all the talking and I'm interrupting, and I'm not really facilitating this employee's opportunity to get themselves off the hook.
Okay.
So, you know, you won't have that problem as much with good representatives as you might with. And so far, everyone I've seen in Corpus is just top drawer.
Why are you looking this way?
No, you're right.
Okay. The next one, C, D, and E, just notice of contemplated action, notice of disciplinary action, contents of disciplinary action notice. Is there much that has changed there? It didn't seem to me
I think
like there was
that
anything that changed, and I just want to make sure I didn't miss something.
nothing's coming to mind. I mean, for the most part, I tried to follow the procedures that y'all have in place.
Okay.
Okay, this was, frankly, this was the hardest article that I've written yet, because y'all have a kind of a convoluted wording that had, you know, said the same thing 2 or 3 times sometimes.
And it's difficult when I'm trying to compare, to try and pick, you know, because it is not organized in an easy way. So
Right.
it is kind of hard to.
But, you know,
to figure it out.
except for the right to union rep, this deep in the article, I don't recall any like
Okay.
substantive changes.
I think the timeline was pretty much the same too, the 10 days after receipt.
Probably. Subsection 3F,
That's what I was looking at.
that I think tried to clarify what I thought was a murky provision in your current contract about how criminal allegations can change those timelines. You know, the Civil Service Act uses a 180-day requirement. I stuck with the 6 months in your contract because it's a lot easier for people to count 6 months than it is 180 days.
That's right. Other than trying to clarify what was in there, was there anything that was much different?
I think that's what I'm saying. I think it may be a little bit different.
Okay.
You know, as I recall, when there were criminal allegations, you know, it looked to me like the thing just ran the time limit up to the criminal statute of limitations. And that's problematic from our perspective because almost every misconduct allegation might violate some federal statute. Just to use an example, I mean, if you are accused of falsifying your timesheet, well, there's a criminal thing for falsification of government records, and you know, so there's a difference between when there's an active criminal investigation and when really it's just an administrative investigation. Normally, falsification of timesheet is going to be handled as an administrative matter. You're not going to necessarily boot it over to the district attorney's office.
Okay.
So yeah, that I think that is different.
And then the appeals of, let's see, the appeals of disciplinary suspension and discharge look, section 4A pretty much looks the same as far as I could tell.
It is. You know, I put that language in there about 3 or 4 times now, Saturday, Sunday, or city observed holiday.
Right.
That is one where, you know, if we wanted to, we could just add something to the definitions article that says
Okay.
when there's a time limit and the last day falls on a Saturday, Sunday, or city observed holiday, you know, so that we don't have to repeat the same thing over and over. I don't mind repeating it over and over because I like it when an employee looking at the contract can find everything they need to know in one
Right.
section, so.
That's not the case with this last contract on the grievance procedure, because that Saturday, Sunday, or holiday was embedded in some random paragraph at the end.
Well, I know, and sometimes it's put in a section that refers only to say this type of thing, but then it clearly from the context is meant to apply in other situations
Mhm.
too, so. There's that kind of cleanup.
Okay, and then section B seems to mirror the same selection of an arbitrator.
Right, I put the coin flip in there too, I think.
I think the hearing date is the same. The hearing transcript, this is different. The parties would have to agree to order the transcript before the
You know-
proceedings. If there's no agreement, the party desiring so may have a transcript made at the party's sole expense. However, in the case of transcript, will not be shared with the arbitrator.
I put that in there because, and I'm talking off the top of my head, so if I'm not remembering right, but I apologize, but I think I am remembering right. It just said that, I think that your current policy just says, well, you know, a party can have a transcript made and if only one party makes it, they bear the expense. But then that begged the question, which was, well, okay, if only one party wants the transcript and pays for it, do they share it with the arbitrator? And your contract is silent on that.
Right, and then what
Most-
happens if the arbitrator asks for it
Well,
afterwards?
that's
the other thing, 'cause
what's
happened
gonna
before.
happen, yeah. The arbitrator is normally gonna say at the outset of the hearing, is there gonna be a transcript? And if one party says, we don't want a transcript, Mr. Arbitrator or Ms. Arbitrator, and we don't want you to look at the transcript, the arbitrator normally will acquiesce to that and say, okay, well, I'm gonna work off my notes then, and they'll make a lot better notes than they would in that case. In most disciplinary cases, probably both parties are gonna want a transcript, because that's the one that's most likely to probably be appealed.
Mhm.
So, I don't see it's a problem, but, you know, if you wanna say that, you know, counter it, well, we're gonna always gonna make a transcript, fine. You know, we'll certainly look at that.
And I looked, was there any, I looked and I couldn't find many other changes on
No, the
rest.
pre-hearing and hearing procedures, I pulled it from several places, but
Mhm.
it was meant to mirror, I think, what is in your contract currently,
Okay.
including the use of the AAA rules and all that good stuff. So I think that's all in your
Now,
contract.
the payment of the arbitration expenses, shared between both parties, is that the same?
Yeah, I think that there may have been some language in your current contract about when the association will bear the employee's cost.
Okay.
And really that, I think, is between the association and the bargaining unit member, and really doesn't need to be a part of the contract. I mean, the case, obviously, discipline is different from contract grievance arbitration. Discipline, the firefighter gets to decide if they're going forward to arbitration. And if a firefighter goes forward with an arbitration of a disciplinary case that should not have been arbitrated, you know, because it's, you know, you moon the mayor's wife or husband, as the case may be, and we know we're not gonna win that, you know, we don't wanna pay for a transcript maybe.
Okay.
See what I'm saying?
I see. Mhm.
But we don't get to make that call. We wouldn't have arbitrated that grievance if it was up to us.
That was a good
Right.
scenario.
Okay, and if, And I think everything else is the same. Status quo is the last contract.
I think so. I do want to say this about demotion, section 5.
Uh-huh.
You know, the Civil Service Act has this kind of cumbersome procedure where, you know, the fire chief can't demote. They recommend a demotion to the commission. The commission decides if there's probable cause. If they do, then there's a hearing. And this, it wasn't clear to me whether your current contract scraps that or not, but this clearly does scrap that. The fire chief can decide to demote, subject to the firefighter's appeal rights. Okay, so we don't have to have that double decision, you know, first fire chief, then commission. And I've talked to the firefighters. There really have been very few involuntary demotions, and demotion is not common, in my experience anyway. So. The judicial appeal standard is the 057J standard, the civil service standard. So.
And that's all my questions on 25.
Okay.
Okay, 28. We'll go. Do you mind going to 28, the impasse procedure? The first question I have is section 1A, you have the impasse, and impasse is also addressed in that Article 27, section 2 that you have proposed during this negotiation session. And it gives us a little bit broader, a little bit more room to work with those 60 days more than what is provided by Chapter 174. Is that correct?
It does.
Okay.
Chapter 174, you got to extend in writing 15-day increments. This
And
allows
60
us
And
to.
it's 60 days, no matter what, from the day that you started bargaining, doesn't take into consideration breaks or anything like that?
Right.
Or
So
time.
this is intended to give us a little more flexibility. It more or less preserves the same amount of time on the low end,
Right.
but it guarantees you get 60 days.
Right.
But other than that, it's really flexible between the parties. But what it contemplates is when the parties say, we're just not making any more progress arguing between ourselves, go to impasse and start using this procedure.
Okay. And the extensions are not going to be limited to those 15-day increments. We can determine them as specific periods between the parties.
You could, and you could even say, let's both sign a letter. I mean, I always think it's good to put things in writing. Let's both sign a letter that says we'll extend until either party says,
Okay.
you know, so,
Says uncle.
yeah.
Now, with these proposals in mind that have to do with the impasse and this impasse procedure, it's written very broadly, and so I need to ask some specific questions so we can understand
Okay.
what the impasse means and what this procedure is going to entail. Will an impasse occur on that non-mandatory issues? I know that.
No, can't. I mean, under the Fire and Police Employee Relations Act is modeled after the National Labor Relations Act, and neither party can insist on negotiating about a permissive subject of bargaining, and you can't go to impasse because another party won't talk about a permissive subject. So this only is with regards to mandatory subject of bargaining.
Okay.
I mean, we might argue about what's mandatory and what's not.
Yeah, and that was going to be my next question. The only reason I ask about that is because as this impasse procedure is written, when we're talking about going to mediation and fact-finding and potential binding arbitration as you propose here, it basically says generally that any issues that aren't agreed to that have been proposed on the table become issues in dispute. And my question was, we both know what the rules and the basis are, what we can
Yeah.
negotiate at the table, but when we're doing this, a collective bargaining agreement, this could be implied to override that, and that we would be committing ourselves to having to go to mediation or fact-finding or potentially a binding arbitration on something that we didn't want to negotiate, something that was permissive and we didn't want to negotiate about.
And
So
that
that's-
was not our intent.
Okay, and I just
mean,
wanted to clarify that.
Yeah, the
Get
impasse
that.
procedure would, I think, legitimately be limited to mandatory subjects of bargaining. So if we made a proposal about something that you felt was permissive, I would, and we tried to make that a disputed issue, I would think that you could put that before the fact finder and or the arbitrator that no, that's permissive and you can't really rule on that. And I would think you could even go further than that, but that's the sort of very limited thing that you could appeal. If you feel like the arbitrator just got it wrong, they took a clearly permissive subject and made it part of your agreement against your will, but that's the sort of thing you could appeal.
Now, we both know that, you know, unfortunately, these mandatory subjects are not very well defined for either party, and one of them being specifically conditions of employment, you know.
Mhm.
And there are some guidelines that have been provided to us about what may be mandatory subjects under conditions of employment, et cetera, but there's a lot that's not. And so there may be times that we're gonna disagree about what is permissive and what is mandatory. You know, we may think something, it's gonna probably wind up that you may think something is mandatory and we're gonna think it's permissive. So are you, in this proposal, is the intent for that argument to be resolved through mediation, fact-finding, and the arbitration as well?
No, I don't think so. I mean,
Okay.
what is, I think you always have a legal right to insist all the way through and appeal to the courts. I would hope that the parties would be guided by what a fact finder and an arbitrator would say, but I think ultimately that's one of those few issues where I think you do have the right to go to court, because that is ultimately what's mandatory and permissive is I think largely a legal determination.
Right, okay. That answers a lot of my questions on the permissive subjects with regard to this.
You know, can I just say generally about the procedure?
Sure.
It ends with the arbitrator hopefully deciding only a few issues, but rendering a binding decision by picking one party's package or the other. I really got that out of the proposal that the city made last fall, or maybe it was last year. But at any rate, the whole thing is supposed to be a win-win process. We agree to some stuff, you know, but you're not locked in because you made a tentative agreement. You can pull it back into disputed items.
Okay.
But hopefully we resolve as much as we can among ourselves. We have the opportunity, but not the obligation, to use mediation through the FMCS. Then we go to fact finding. We can reconfigure our proposals at that point, and the fact finder picks one or the other on each disputed issue. And then we get together after that, and we look at what the fact finder said. And hopefully we take a few more things off the table. And then, so maybe we send 10 to the fact finder. And after the fact finder, we look at it and we say, we can agree on 5 of those. Now there's only 5 that go to the arbitrator. But the arbitrator is going to pick one package or the other. This is kind of y'all's idea. And, not kind of, it is y'all. And, you know, we have a chance to modify our proposals at that point. The idea is that everybody's trying to become more reasonable because you want to be the winner. You want to be the person whose package gets picked. So it really puts increasing pressure as you get further down the pipe.
Creates a funnel to try and narrow the issues.
Really, and it should, if it works well, and since I wrote it, I think it'll work splendidly. Giving
You know
credit
what?
where credit is due.
Absolutely.
Yeah, the idea is that hopefully by the time you get to arbitration, you're just down to a couple of things, and then, you know, the arbitrator decides. And, you know, the factors that both the fact finder and the arbitrator consider are those that are in the contract presently. The contract. So I'm not making a lot of changes there.
Okay.
So, but it gives us a way to get a contract impasse resolved in a way that's fair to both and really puts pressure on the two sides to try and come to agreement.
Well, I'm encouraged by this proposal because I think the impasse procedure is going to be a driving force on a lot of the issues that we're negotiating on in this particular contract. Like I've said, one of the key things, our goal has always been to arrive at a fair and equitable contract. Unfortunately, the impasse procedure that was in the last contract was kind of a spinning, just a spinning wheel that we had no way to come to an end.
Yeah.
It would throw us off into the oblivion, and then we had to find our way back somehow. And
Yeah, the
so-
merry-go-round just starts spinning faster and faster.
Yeah,
And
that's
you're going
right.
down the rabbit hole.
That's right. And so, so I'm encouraged by this, and I think that this is, if we can figure out a good, workable, fair impasse procedure that puts both of our end goals in mind, which is to get to a contract and within a reasonable amount of time, I think that it's gonna, it's gonna encourage the negotiation of the other proposals, with regard to duration, that we've gotta talk about that. And I think, like you said, this impasse procedure will directly affect how we negotiate, what we talk about with regard to that duration
Yeah.
clause.
For sure.
So, okay.
Okay.
And the list of agreed disputes, basically, we would just say what we think, or what we would just say what our disputes are and what your disputes are, and then we all agree to just put them all on a sheet of paper.
Yeah,
Okay.
we just,
We can't disagree to what you want to dispute.
No, absolutely
You can't
not.
do that, okay.
I mean, and the whole idea, of letting you pull tentative agreements back out and put them in the disputed column is so that you're not afraid to make a tentative agreement, because you have that safety net.
Right. Well, and that's another thing, because, we may make tentative agreements, and individually they may make sense, but then when we come out of mediation or fact finding and there's a resolution on some stuff, and then we come back and we negotiate, and then we come to a resolution on bigger items, and then that TA doesn't quite fit in yet, we probably, if we leave it open to be able to just, skew it and tailor it in a way that fits with the whole contract, and I think that's a good approach.
Yeah, I agree.
Okay. Also, this proposal sets forth that fact-finding would be mandatory even without mediation, is that correct?
Yes.
Okay.
But it is something that I don't know how y'all react to, and I'm open, but what I'm proposing is there really only be one hearing. You do the hearing in front of the fact finder, and then, like I said, maybe there are 10 issues, and so after fact finding, you got it down to 5. Well, why hold another hearing about those 5 issues? The parties meet and they say, okay, here's the portions of the record that deal with those 5 issues. We put together an appendix, which is the testimony of the witnesses and the exhibits of the parties, and we give that to the arbitrator with post-hearing briefs and get a decision.
Oh, so you're proposing having I didn't understand, you were proposing having one hearing, all done at the fact-finding level,
Right.
and then using all that evidence and that transcript, et cetera, and then if we go to a binding arbitration,
The
providing that
arbitrator
to the
rules-
arbitrator, and then providing him with an additional brief.
Right.
But with no rebuttal briefs where I get to rebut you and you get to rebut me.
That's
We just
right.
do our post, okay.
That's right. And I mean, some people get, your first reaction to that might be, it might make you a little nervous because you're thinking, well, maybe I didn't do a good job at fact finding or whatever, or maybe I thought that one of the witnesses at fact finding was lying, and how's the arbitrator going to tell that? I mean, we could even agree to videotape the fact finding hearing, so the arbitrator can actually see the witnesses and make a decision for him or herself. Or, you may want to counter and say, no, we really want a second hearing. I mean, we're not foreclosing that. We're just saying that we're trying to make the process kind
More
of speedy.
efficient, right.
Yeah, more efficient.
One of the only concerns I would have, and this could be easily addressed, and I'm just gonna let you know. One of the concerns I would have with foregoing that second hearing would be having the opportunity for that new arbitrator to ask the questions he thinks are relevant, he or she thinks are relevant or whatever. So we would probably, somehow enable a mechanism where that could happen and that both parties would be able to respond.
Yeah, and the other thing that I didn't
So,
think
yeah.
about was, you have an opportunity after the fact finding to change your proposal yet again.
Mhm.
I wanted a
Oh,
5%
that's right.
raise, you wanted a
That's right.
1% raise. The arbitrator said, well, I'm gonna go with a 5%, because that's closer to what I think, but really I think a 3.5 would be reasonable. City might look at that and say, okay, well, now we're gonna come back with a 2.5 instead of a 1. Well, you may need to do another hearing.
But
or
on that
put-
one issue, maybe.
Yeah, because
Yeah.
maybe it makes sense, maybe we can find a way to make the hearing an abbreviated hearing, but still give everybody another, opportunity.
Okay, I see. Okay, and issues to be submitted to the fact finder, and I guess the mediator as well, mediator and fact finder, and ultimately the arbitrator would be the issues that would just be limited to what
Is
the
in dispute.
mandatory proposals that had been put on the table, right?
Right,
We couldn't all of a sudden put out some new proposal, some new issue. I mean, we have our
No.
deadline on March 5th. So
Yeah,
we-
I mean, if you look at section 1C, no new issues allowed,
Okay.
We never talked to you about parking throughout the negotiations, but now we say, hey, let's have the fact finder decide parking. Can't do that. I hadn't thought of the whole permissive versus mandatory when I was writing this. And so, I mean, the way I think we resolve that is, we have our list of disputed issues, but you can certainly say with regards to any particular issue, city takes a position that this is a permissive subject and therefore not properly before the arbitrator. So.
I have a question, but I need to look to find where it came from.
Okay.
I thought I usually highlight it, I didn't highlight it here. Okay, at fact finding, you're saying, we would submit a proposed resolution to each disputed issue, so it would basically be what our proposal is that we want to submit to them.
Yeah, base wages, here's our base wage proposal, there's yours. By that time, we probably agreed on what the articles are and what are the disputed ones. Maybe there are, like in our contract, I think we've got 34 currently. Maybe we agreed on 25, and there are only 9 to go forward.
Okay.
We would give him our 9 proposals, you give him your 9, and the arbitrator picks one or the other on each issue. But has to explain his or her reasoning. And so what that gives us an opportunity to do is to, look at what was said and figure out if we want to change our proposals. Maybe we can reach agreement. Maybe the fact finder says something that we hadn't thought of that makes us think we're liable to lose that one, and so we move closer to you, all of a sudden we get agreement.
Right.
So the whole thing is designed to winnow it constantly.
Okay.
So the arbitrator doesn't decide that.
Okay. The factors listed in section 3F, what the fact finder is going to base their recommendation on, were these the same ones that were in the?
I think they're in the current
contract
contract, and I
before?
also think they're in the city's proposal from last year.
Okay.
I don't remember adding anything that wasn't in one of those 2 sources. I reworded them somewhat,
Okay.
but the intent was not to change. I
The
don't
same
think.
subject matters or the ones in
Yeah.
front? Okay, and then the fact finder is just a recommendation, and it's either pick this, it's an issue per issue at that level,
Mhm.
and,
Issue per issue.
and he or she would pick either one proposal or the other. Is that
That's right, yeah,
Okay.
they can't split the baby with the bathwater. They gotta decide, one or the other and explain why. And, you know, I assume that often a fact finder will be constrained by that and say, man, I wish I could go in the middle of these two.
Mhm.
But explain why they picked one or the other, and then we both look at it and decide if we wanna keep pushing or we wanna try and reach agreement on that.
Okay.
It's an attempt to really get us to listen to the fact finder, but, you know, at the same time, you're not ceding any authority to the fact finder, because that ultimately has the right to go to arbitration.
And then the party meeting on the fact finder's recommendation, see, within 14 calendar days after the fact finder's recommendation, we would have a meeting to try and negotiate, mediate some of the additional issues that are left after that.
That's right.
Are you limiting this to one meeting, or would the party meeting last however long it needed to last?
I
Because
think
it
the
could
party
be
meeting-
one issue, it could be 10, you know?
That's
so-
right. I think the party meeting, you know, can, and in some cases would, last a couple, 3 days.
Okay.
You know, it just depends. And I think the parties, especially if they're making progress in that meeting, can say, yeah, let's keep this going.
When we go to arbitration and you're saying, fact finders issue by issue, and then we finally go to arbitration and it's a package deal, is that gonna be the last best final offer kind of?
Last best final.
That's
exactly what that
what
is.
you entail, okay.
Yeah. And, you know, again, as you're approaching arbitration, you can change your proposals, again, in response to the fact finder's recommendations. So it's forcing the parties at each step to become more reasonable. If you look at 3H, oh no, I'm sorry, it's actually within 7 days after the 3H meeting,
Mm-hmm.
You know, the parties' representatives can meet and share with each other the packages that they're going to submit to the arbitrator. And then you look at my package and think, uh-oh, he came in more reasonable than I did. I'm going to shift mine a little bit. So there are no surprises. When we get to arbitration, we both know what the other's package is going to be. We both struggle to be as reasonable, hoping we're going to win. And the arbitrator picks one, and we can't split the difference.
And again, the idea is communication, because something like what you have proposed won't work if we show up to fact finding with a whole new package, surprise here. I mean, that just doesn't make sense.
No, you have to be an open book.
Right.
By the time we get to arbitration, we both know what the other person's package is. We can't change the packages mid-arbitration hearing. So you just gotta hope at that point. But
Okay.
that forces us, before the day of the arbitration hearing, to get as close to reasonable as we possibly can.
Okay.
And then that final section, the successor agreement is everything we've agreed to at each step of the way, plus the package picked by the arbitrator. Obviously, if we agree to everything at the end of fact finding, there is no arbitration.
Right. Okay.
Or at the end of mediation.
At the end of 60 days?
Yeah, like we're gonna do this time.
That's right. Those are all my questions on 28. And then,
34.
okay, with involuntary promotional bypass. And this was something that was already in the last collective bargaining agreement.
It was in the agreement. I think it's it is section 4 of Article 10, which is the disciplinary section. But I think
Which it didn't fit quite.
It
the
didn't, because
disciplinary.
a promotional bypass doesn't necessarily have to be disciplinary.
Right.
You know, I mean, promotional bypass may be for legitimate reasons that really aren't a slam at the person who's being bypassed.
Now, were there any major changes on
I
this
don't
one?
know. I don't think that I have changed what's in the existing contract. I've made it a little clearer. Section 2 is something that I've added. but it's my understanding that that is the current practice in the fire department.
Okay.
You can confirm that or with the chiefs hopefully, but that is not a change from the bypasses in this fire department, and fire departments across Texas are very rare anyway, so.
Okay, I did have some questions on the section 1C and section 2. Because on both of these, it says if a firefighter who is bypassed 3 times without successful appeal has his or her name removed from the promotional eligibility list. And the same thing on somebody who voluntarily declines 3 separate positions. Is there a time period? Eligibility lists, promotional eligibility lists are only valid for a year.
Right.
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 So I'm guessing would that time period be would those 3 times have to be within that time period of a year?
Yeah,
Okay.
yeah, that's right. And it can happen. Obviously, you don't have as many promotions to captain say as you do to firefighter too. At the lower promotional ranks, you know, there may be 10 or 12 positions filled in a given year. Depends on the size of the department and just the vagaries of when people retire or resign.
Okay. I just wanted to make that clarification because it could read either way, the way it was written.
Yeah, no, you, yeah, it's per list, so.
Okay, for this. On section 2 on voluntary promotional bypass, I was just wondering what happens if all the eligible people for promotion refuse and there's a vacant spot left, we just have to fill it according to the hiring procedures?
You know, I only know one case where that came up, and we ended up litigating it, and unfortunately, we got a decision that didn't get appealed, so it's not a precedential. But what happened was, I think the gist of it was that if you get to the end of the list and everybody's voluntarily bypassed, that you then can produce a second list.
Okay.
And fill it from that list. That doesn't mean the first list goes out of existence. The first list will still be the primary one. But you could go ahead and do that in that case. You should not be hamstrung in your ability to fill a position, but it's not, you know, so it's not intended to hamstring the city. No.
Yes,
You gotta go through the list 3 times.
You gotta go through the whole promotion.
3 times.
3 times.
Well, if I'm hearing the guys right, you know, let's say that you've only got 4 people left on the list. You have a vacancy. And they all decline,
All decline.
then you go through it again, they all decline, you go through it again, they all decline, and then and then the list is dead.
I would never see that happening, but yeah,
Usually,
it's possible.
usually they'll be like, okay, I have no more chances, I'll just take it.
Yeah.
So,
So,
they don't have the right to do that.
you understand what
3
they're
times.
saying?
They
They're
just
saying,
keep going through the list until somebody fills it?
You have to give them their
basically.
3
Until somebody gives in.
chances to decline. I mean, that's the way the policy's written.
I guess what they're saying, and this makes sense to me, is, hey, look, guys, we're gonna go through this 3 times, and if you all 4 say no 3 times, the list is dead,
I
and
see.
we're gonna make another list. So you really want, this is your third, this is your third case to pick. You really wanna say yeah, no,
Okay,
one
yeah.
last time?
I don't think we actually have a procedure that if all 4 said no.
No,
That's
you
why I
won't.
was asking.
There's not
The guy in the last position has the advantage.
Yeah.
In that rare
That's when it pays to
circumstance.
be last.
Yes.
I think you're gonna find that we're talking about something that'll never happen, that you'll never actually exhaust the
I
list.
think I can think
We've
of only
said
one
that on
person.
some stuff, and then there's that one time.
Well, let me tell you.
It'll all be dead and gone.
But it's
Right.
good to spell it out in the contract,
Yeah.
because like I said, I litigated a case for like 2 years on what happened to a guy that voluntarily bypassed, and so.
Okay.
I wish we had gotten a court of appeal decision, because it'd be nice to have something out there saying what the statute as it's written means. It's not clear at all what happens on the voluntary bypass.
Let's see. Okay, we've gone through the questions that I've had. Anybody else have any other questions on the, Article 24, 25, 28, and 34? Okay. We got a lot of good information on this. We've, gotten all our questions that I have so far answered. I'm sure that as we continue with these negotiations, a couple issues will pop up and more questions, et cetera. But at this time, we're gonna go ahead and caucus until, we're gonna request that we caucus until next Friday, and we will prepare our stuff. I know that there's still a couple more that y'all
Yeah.
are, but
And let me just say-
we'll have something for,
Let me just say that briefly. I mean, what we've got left, that I'm very hopeful to give you something next Friday. EMS, promotions, miscellaneous. Okay. EMS, you've asked us for a proposal. Before we do, we consider doing IBB.
that's right.
But this is a really difficult issue. I can just tell talking amongst ourselves, and we've been looking at the proposal you guys made last year, and so we kind of identify where the issues are. And so what we're going to do next week is give you a proposal that addresses our issues.
Okay.
And we understand that you guys have a dog in the hunt too. We'll expect a proposal back from you that addresses your issues, and then hopefully, at that point, we've identified the issues. I really do think that this may lend itself to IBB type bargaining, that we're really trying to find some kind of solution that's win-win.
Okay.
Because we do recognize the city has a legitimate interest and need in filling all these ambulance spots. We have people that have had rights under the contract for years that have legitimate expectations that those rights will continue to be observed. So it's going to require some compromise on both sides. I truly believe we can get there, but I'm just saying, don't expect our first proposal to be a solution. It won't be. It'll address our concerns.
No, and I understand that. I understand that.
Somebody probably missed me.
I'm going to take that in just a second. That's my aunt,
Oh,
the nursing home.
yeah, I know.
Probably the nurse calling.
That's right, and that's what I'm asking you, what we're asking for you is your initial, the baseline basically, because we just really need to identify the issues, and that's what we're gonna provide to you as well. Our baseline is what we're looking
Okay.
at. We need to both have starting points and,
Yeah. Okay.
that way we can negotiate and hopefully find a medium.
Okay, very good.
Okay, all right.
See you guys next Friday.
Yes, and the next 3 meetings are posted. I emailed you. If you need copies or anything, any questions, just feel free to email me, okay?
Will do.
Okay, thank you.